Now, this was not part of the journey, but we are going to discuss disputes. Disputes are by no means inevitable. Disputes in franchising are mercifully rare, but they do arise because, just imagine this, a franchisor has 100 franchisees, all of whom have entered into 5-year franchise agreements, and the franchise agreements are 40, 50, 60 pages long. Now, that is a sort of recipe for a potential legal dispute. So you can understand why disputes arise. They tend to arise from a franchisee's perspective because you don't think that the franchisor has done what the agreement said he would do, or the franchisor told you, gave you some information to encourage you to enter into the franchise that turns out not to be correct. So very often you see breach of contract and what lawyers call misrepresentation claims. Now, if I just say one thing to you about disputes, and that is, don't get involved in them. Resolve them amicably. The only people who win from disputes are lawyers. Now, that's delightful if you want to make lawyers rich, but very few people, unfortunately for me, actually want to do that. So always try to find an amicable solution. Raise issues with the franchisor, communicate to the franchisor and say why you're not happy, what it is that you think the franchisor should do differently. Also, listen to the franchisor, and if the franchisor says you're not doing what you should be doing because you think you know best, listen to the franchisor and actually contemplate doing what the franchisor wants you to do. So always try to resolve disputes amicably. Don't rush into going to see a lawyer. Now, how are disputes in franchise agreements resolved? Well, there are 3 ways. And by far the best way, and you need to check the franchise agreement to make sure that this is in the franchise agreement, is mediation. Mediation is relatively cheap, relatively quick, it's confidential, nobody forces, nobody decides who's right or wrong, but the role of the mediator is to put the parties together to find a commercial solution. That's a really good way to resolve franchise disputes. So check the franchise agreement to make sure that there is a mediation provision. A less good way is arbitration. The British Franchise Association has an arbitration scheme, and again you need to check the franchise agreement to see if that's in there and obtain the franchisor's confirmation that he's happy to use the BFA's arbitration scheme. The least good way is litigation. Litigation is mind-blowingly expensive. You have no idea how expensive it is. And of course, bear in mind that franchisors really don't want to lose litigation. They use expensive lawyers, and if you lose the litigation, not only will you have to pay your own lawyer's fees, but you may also have to pay the franchisor's lawyer's fees. There are conditional fee arrangements and after the event legal liability insurance that's available sometimes, but not always. Secondly, litigation, the result of litigation is uncertain. Lawyers always say to their clients, look, even if you have a case you absolutely can't lose, you will only win in 70% of occasions. Now, that means, if you flip it, that 3 times out of 10, you've got a case you can't lose, you lose. So it's a really uncertain process. And lastly, the stress is just extraordinary. So the one message about disputes is do everything you can to make sure that you don't get to a situation where it gets litigious and you need to go and see a lawyer.